Start. Sir, it had been further argued on behalf of the defendants that under Section 34 of the Specific Relief Act, the plaintiffs must have a direct interest and entitlement over the property, for which the declaration is sought. Full stop. Section 34 of the Specific Relief Act states, discretion of court as to declaration of status or right, full stop. Any person entitled to any legal character, or to any right as to any property, may institute a suit against any person denying, or interested to deny, his title to such character or right, and the court may, in its discretion, make therein a declaration that he is so entitled, and the plaintiff need not in such suit ask for any further relief, provided that no court shall make any such declaration where the plaintiff, being able to seek further relief than a mere declaration of title, omits to do so, full stop. In the present case, the plaintiffs are not seeking a declaration that they have a beneficial interest, full stop. A derivation action is sought only for the beneficial interest of the second defendant, full stop. The second defendant has, however, abjured such interest, full stop. Whether such disclaimer or abjuration is the result or effect of collusion or fraud are further aspects to be examined, full stop. Such abjuration has to be weighed with the flow of funds through the second defendant to the first defendant, leading to the allotment of shares to the third to the seventh defendants, full stop. Examining all these aspects can only be through advancing oral and documentary evidence, full stop. This would further imply that the suit has to be retained on file, full stop. It had been further contended that the suit relief is barred under Section 187C of the Companies Act, 1956. Full stop. It had been contended that in the absence of the above declarations, seeking a declaration against the first defendant would be akin to put the cart before the horse, full stop. I hold that the declarations made or not made in the books of the first defendant would be to the exclusive knowledge of others, full stop. In this context, the 8th to 10th defendants have a vital role to play, full stop. Evidence is necessary from their end to disclose facts and to subject themselves to cross-examination on all these aspects, full stop. The plaintiffs have pleaded the facts to their knowledge, full stop. It must also be kept in mind that except the third defendant, no other defendant had sworn to an affidavit, full stop. Questions raised by the plaintiffs remain unanswered, and trial is the answer to determine the actual facts, full stop. I hold the plaintiffs cannot be non-suited at the threshold, full stop. The suit is only at its early stage, full stop. It still has a rough course to clear, full stop. The reliefs sought may be superfluous, but if the plaintiff discloses a cause of action and if the plaintiffs are prepared to battle out the issues at the time of recording the evidence, then again they must be afforded such opportunity, full stop. At this stage, the plaintiffs have come to court primarily claiming a declaration as against the first defendant, full stop. Whether the third, fourth and seventh defendants on the one hand and the second defendant on the other hand have made declarations in accordance with the provisions of either Section 187C or Section 89 of the Companies Act 1956 or 2013 are facts to the exclusive knowledge of the first, second, third, fourth and seventh defendants and also the eighth defendant, full stop. The plaintiffs could never have had access to the records of the first defendant, full stop. The queries raised in the pre-suit notices have not been answered, full stop. Consequently, they have sought a declaration only against the first defendant, full stop. This declaration is sought because in Dubai, the third, fourth and seventh defendants had made similar declarations and in the plaint, the plaintiffs have stated that they believed that similar declarations had been made in the books of the first defendant, full stop. This statement of the plaintiffs has to be tested further through oral and documentary evidence, full stop. Consequently, I am not in agreement with this contention raised by the defendants, full stop. Trial is the answer to settle facts, full stop. At this stage, the plaint averments hold the sway and a reading makes it obvious that the first defendant has to open up its records for scrutiny, and that can be done only during trial, full stop. To sum up, the allegations raised in the plaint have to be examined at the Chennai since, the first defendant is registered in Chennai, full stop. During its pre-incorporation, incorporation and post-incorporation stages, substantial amounts of money had flowed to it, full stop. It is only with examination of the books of the first defendant that the source of the funds can be determined, full stop.